Welcome to Prediction News Update. I'm Chris Gerlacher with Prediction News, and we just got a decision in Massachusetts State Court. It's Kalshi's first loss at the state level, and we'll be talking with sports betting appellate lawyer Daniel Wallach about the implications for the prediction market industry after this momentous milestone. To make sure that you keep up with all of our legal updates, like this video, subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News for our breaking news coverage. Before we get into the meat of what we're talking about today, I want to introduce all of you to Prediction Edge. The 2026 elections are going to be a wild ride. They're the first midterms with prediction markets at scale, and more than 450 House and Senate seats are up for grabs from incumbents and the new wave of rising candidates alike. Prediction Edge is a new election platform that brings together real-time prediction market prices, candidate profiles, fundraising, polling data, and endorsements. Prediction Edge is the smarter way to follow elections this election season. Now I want to get into the big news of the day, Massachusetts. Dan, how did Massachusetts win this case against Kalshi?
By suing in state court, Massachusetts had a much lower bar to clear once the case was remanded to federal court. So once the judge in the federal bench remanded to Massachusetts because Kalshi was not able to demonstrate complete preemption, that's a much higher bar that Kalshi has to clear to sustain a removal than it would have had to clear if it had just filed a federal lawsuit in the first instance. So striking first, I think, was the key here. And then once it was remanded back to state court, you're dealing principally with state law issues being decided by a state court judge. And I've always viewed this as more of a slam dunk for Kalshi, for the Commonwealth, mainly because once you're focusing on the state law components of it, Kalshi has a much more difficult argument to overcome. And Kalshi leaned heavily on its federal preemption argument, even in state court. They didn't put up much of defense around the state law issues, save for the preemption argument. And the only, I guess the only hesitation by the court was the concept of evolving or dynamic preemption. The judge was unclear, unsure at the time of oral argument, whether in interpreting the preemptive effect of a federal law, he should consider the state of play in effect at the time that the Dodd-Frank Act was enacted, or consider later events, such as 39 states in the District of Columbia legalizing sports betting, and whether that may or may not bear on the issue of congressional intent. And he opted quite reasonably for the former, because when Congress is enacting a statute, it cannot have a crystal ball and envision what may come down the pike 15 years hence. In determining congressional intent, which is the main question on preemption, which is, the preemptive effect of a federal statute is a question of congressional intent, and congressional intent is measured as of the time of the enactment of the statute. It really became a slam dunk at that point, once the judge understood that preemption was focused on the state of affairs in effect at 2010, and he adopted an almost identical analysis as what U.S. District Judge Adam Abelson employed in Maryland. He focused, or at least he identified, the strong presumption against preemption in areas that have traditionally been regulated by the state, such as gambling. And with that strong presumption against preemption being the starting point of the analysis, Kalshi would have had to have demonstrated clear and manifest and specific congressional intent to displace state sports gambling laws. And once the pendulum got shifted heavily in the Commonwealth's favor due to that presumption against preemption, it was lights out, for Kalshi. And I think it was a result that most expected. I certainly expected it when I did a little bit of a deeper dive on that dynamic preemption question.
It was interesting to see the judge's one opening that it gave Kalshi just be completely absent in this opinion. He's got not long sections, but several page sections on field and conflict preemption, and neither one appears flexible. What's the significance of that going forward for even Kalshi's appeals through the state, which seem inevitable?
Well, the appeals and the issues of the stay are going to go to appellate courts, and appellate courts don't owe any deference to Judge Barry Smith's decision on issues of preemption or statutory interpretation. Those are pure questions of law. So the Massachusetts Appeals Court, the Massachusetts Judicial Supreme Court, they're gonna look at it anew, almost in a de novo capacity. But given the analysis that was employed by Judge Barry Smith, which follows on the heels of 5 straight federal court rulings in favor of the states in their battles against prediction markets. I mean, this all began back on August 1st when U.S. District Judge Adam Abelson in Maryland began the first of many federal court decisions which denied or dissolved preliminary injunctions, to the prediction markets. He ruled against Kalshi, and then in Nevada, Judge Gordon ruled 3 successive times against crypto, against Robinhood, and against Kalshi on their preliminary injunction requests. And then you had the Maryland Federal Court's order of remand, which rejected Kalshi's federal preemption, complete preemption argument. So now we have 6 court rulings in a row, and I think it's significant precedent that's beginning to build up, because now we're not just focusing on an outlier decision or maybe an exception of 2 or 3 decisions bucking the trend. This is now the trend. The only state, the only federal court which has at this point decided the case preliminarily in favor of Kalshi is New Jersey, and that one is on appeal to the Third Circuit. Every other federal court, Maryland, Nevada, initially Massachusetts, and now in state court, has signaled that the state has the better legal argument, and that the Dodd-Frank Act was never intended by Congress to open the floodgates for national sports gambling under the supervision of the CFTC. I mean, that's kind of an absurd argument in light of the sports betting prohibitions that Congress had put into effect as of 2010 through the Wire Act, through PASPA, those 2 statutes. And Judge Barry Smith highlighted that in his opinion, that those 2 federal statutes represented Congress's view and Congress's antipathy towards the subject of sports gambling. So in order to overcome those 2 statutes, to implicitly repeal them, Congress would have needed to have been very specific in its design of the Dodd-Frank Act, and not just use tacit language or legal sophistry 15 years later to wipe out the Wire Act, PASPA, and IGRA. So I think this is a result that we're going to be seeing much more of in federal district courts down the line as future courts begin to grapple with the question. I think this tips the scales even further of the states as courts in Ohio, Tennessee, Connecticut, and New York, all at the federal district court, trial court level, will be rendering similar or rendering rulings on PI motions over the course of the next 2 months. So this can really begin what I would think of as a snowball effect in favor of the state governments and in federal courts and state courts, and could enliven or embolden other state governments, which are not yet in litigation with Kalshi, to follow the Massachusetts blueprint. I mean, the only thing Massachusetts did wrong, and I guess I'll have to eat my words here, they didn't hire outside counsel and still won. The way to do it is how Nevada recently dragged Polymarket into the battle by using outside counsel, Mayor Brown, to file a state court lawsuit for injunctive and declaratory relief against Polymarket. So you got to strike first, use outside counsel, and avoid these preemption type battles. So I think what these decisions are beginning to reflect are a significant turning of the tide in favor of the states. And it won't take long before today's ruling to be filed as supplemental authority to courts all over the country that are still considering either appeals in the Ninth Circuit or Third Circuit, or PI motions filed in courts such as Tennessee, Connecticut, New York, Ohio, and so on. Within the next 48 hours, this decision will enter the docket of every other pending prediction markets case.
It's going to be one of those influential cases. And as Kalshi inevitably appeals and tries to push its way through the state court system in Massachusetts, when do sports contracts actually go away from that state?
Not for a little while. First of all, today's ruling was the order granting the preliminary injunction, it wasn't the preliminary injunction itself. At the tail end of his order, Judge Barry Smith indicated that he's looking for guidance from the parties. And by the way, this decision came as a surprise because the original intent from the date of the oral argument was that he would bring the parties in to discuss a procedure on a going forward basis before he ruled on the motion. So he wanted to brace the parties for all the different possibilities and discuss a plan that if he granted the motion, this is how it would be addressed and how contracts would be unwound in the future. Or if he was thinking of denying the motion, this would be the discovery plan and the roadmap of the case going forward. He didn't do any of that. He went right to the decision. So what we haven't seen yet is the actual preliminary injunction setting forth the terms. I think we can all understand and acknowledge that the injunction will bar Kalshi from offering future sports event contracts in the Commonwealth. But today's ruling does not address what will be done with the millions of dollars of existing sports event contracts that are not yet consummated or not yet at their conclusion. How do you allow those to exist and just say, okay, they're going to just play out? Or is there going to be a process for unwinding them? And I think what the Commonwealth may want to do here is not, if their view is that these contracts are illegal, they're not going to allow them to go forward. They're going to request that the court set forth an orderly time frame for Kalshi to unwind those contracts and refund those monies, to, at least insofar as Massachusetts residents are involved. That's what the Commonwealth is going to want. What Kalshi is going to argue is that that's impracticable. It's going to be unwieldy, costly, and they don't have the technology to be able to isolate and identify those persons who entered into trades while they were physically within the Commonwealth. So it's going to be a little bit of a tension going back and forth in that Massachusetts is going to go for the jugular, whereas Kalshi is going to want to protect the existing contracts that have not yet been completed, and they're going to go forward and file a motion for a stay of the injunction pending appeal. That's also on the docket. So what the judge has announced in his order is that he expects the parties to meet and confer over this issue, and by the end of the day tomorrow, for the Commonwealth of Massachusetts to file its proposed preliminary injunction order. And within a day or 2 days after that, Kalshi will respond with its own proposed preliminary order, and there may be an in-court hearing. In fact, there will be an in-court hearing, I believe, on January 23rd to flesh out the details of the preliminary injunction, including the scope of it and whether and to what extent inchoate existing contracts need to be unwound. And as part of Friday's hearing, if it is Friday, I'm not sure the exact day, during the upcoming hearing, the court will also entertain potential motions for a stay. And I think what's going to happen between now and the hearing, I don't think Kalshi can file a motion for a stay of the injunction pending appeal because the actual injunction hasn't been entered yet. But what will be discussed Friday are the sort of the briefing schedule around Kalshi's all but expected and guaranteed motion for a stay of the injunction pending appeal. They're going to have to present it in the first instance to Judge Barry Smith at the Superior Court. If he denies it, then Kalshi will go to the Massachusetts Intermediate Appeals Court and request the same relief. And this process is governed by Massachusetts Rule of Procedure Rule 6, which allows motions for stay to be decided by a single justice of the appeals court. So it's going to go from Judge Barry Smith potentially denying it, then to a single justice of the Massachusetts Appeals Court. Then if that's denied, or even if it's granted, there can be an interlocutory appeal to the Massachusetts Supreme Court over the need or propriety of a stay of the injunction pending appeal. So you've got 3 more levels in the state court system, with the long shot, or not actually too remote possibility, of Kalshi petitioning the U.S. Supreme Court on an emergency basis from the state Supreme Court on a denial of a stay, to ask the U.S. Supreme Court to enter a stay of the injunction pending, appeal and an ultimate filing of a ultimate resolution of the as yet filed petition for writ of certiorari, which could be more than a year away. I think it's unlikely that SCOTUS will grant a stay of that kind of duration. So I think Kalshi's best shots here are before the appeals court or potentially before the Massachusetts Supreme Court. And there may be a basis on which Kalshi would be able to bypass the intermediate appeals court and go straight to the Massachusetts Supreme Court on a discretionary petition. We're all about to, hone up here on Massachusetts appellate practice and procedure. I'm not admitted in Massachusetts. You're not a lawyer, but I'm going to school here, and I'm trying as best as I can to understand the intricate appellate rule system that governs Massachusetts trial courts and appeals courts. So I think, but by the time Kalshi is in a position where it has to geofence, I think we may be talking about a matter of a couple of months, but it's going to come quickly. I mean, three successive rulings by the trial court, the appeals court, and the Supreme Court on a motion for a stay of the injunction pending appeal. I don't think there's a significant amount of time that will elapse while those motions are pending. I think we're looking at, probably 3 to 4 weeks per motion.
Well, we're all going to be members of the Massachusetts State Bar by the time this case is finished.
Yeah. I've been to the Massachusetts Bar Association. The first panel I ever spoke on in my entire life was on the Donald Sterling Los Angeles Clippers, ownership battle, and that was at the Boston Bar Association in Boston in 2014. I think I've come a long way since then, but that was the very first. That is my lone interaction with the Massachusetts bar, with the Massachusetts bar and the Massachusetts court system. But we're going to have to get up to speed on this, and it's important because the time between the injunction being entered and actual geofencing, that's going to be a byproduct as to how quickly the motions for stay of the injunction pending appeal get decided and how those motions get decided. Kalshi may be able to forestall any requirement that it exit the Commonwealth of Massachusetts, but I think it faces an uphill battle based on the legal standard for granting a stay of an injunction pending appeal. You've got to show a likelihood of success on the merits of the pending appeal. You got to show the likelihood of irreparable harm to Kalshi should a stay not be issued. You got to look at the harm to the Commonwealth of Massachusetts if a stay is granted, and then you have to take into account the public interest. And those factors, at least based on Judge Barry Smith's analysis, at least for now, line up decisively in the Commonwealth's favor. So Kalshi will face it is a long shot bid, and now they're not in the federal court system where they've been successful. They're now having to engineer and get these motions considered within the state court system, which is where the Commonwealth of Massachusetts prefers to be. So I think at the end of the day, we're looking at the likelihood that Kalshi will have to terminate existing contracts in Massachusetts, refund all monies to Massachusetts traders, and stop offering sports event contracts within the Commonwealth, at least for the duration of further appellate proceedings, which could last upwards of 1 year or more.
There's one more positive but small development for Kalshi that was good for them in another state court. A week ago in Tennessee, Kalshi got a temporary restraining order barring Tennessee from prohibiting Kalshi sports contracts altogether. That seems like a small step in a larger case. How much should we care about that?
We should care a lot about it, but it wasn't like a victory. This was, I think, a mistake by the Tennessee Attorney General's office. Let me explain why. Well, number one, they sent a cease and desist letter. Mistake number one. Just go right to suit, in state court. Number two, they didn't hire outside counsel. But the biggest mistake the AG's office made in that case was not agreeing to refrain from enforcement proceedings, at least during the pendency of the preliminary injunction motion. Every other state agreed to that. Connecticut agreed to that. New York agreed to that. Even, I think, Nevada had agreed to that. And by not agreeing to refrain from initiating enforcement proceedings, the state basically gift wrapped it, a TRO to Kalshi on a silver platter. And what the judge did in this case was not engage in fact-finding and legal analysis. She just signed Kalshi's proposed order granting the TRO. If you compare the actual TRO with the proposed order that Kalshi submitted as part of its motion for TRO and preliminary injunction, it's the same exact thing. She just rubber stamped it and placed the hearing, or scheduled the hearing on the PI for 2 weeks later. So it wasn't real adjudication by the court weighing the merits. She just reflectively adopted the proposed order with the understanding that she's going to address these issues at the PI hearing on January 26th. But the press, I think, erroneously reported it as a victory. I guess it is somewhat of a modest victory for Kalshi, but there was no judicial fact finding or legal analysis. It was just adopting or rubber stamping Kalshi's proposed order as a placeholder for 2 weeks. And that's the truth of it. But it's been spun in the press and reported by the gaming press as court enjoins Tennessee from enforcing its state law. Victory for Kalshi. I guess in a very technical way that may be true, but as a matter of substance and what we really know is going on behind the scenes, she just did that as a 2-week placeholder, and I don't believe it's going to bind her or influence how she rules on the motion for preliminary injunction, because when she entered that TRO, Tennessee had not yet filed its opposition. Tennessee had not yet appeared in the case. She based it almost like on an ex parte basis without hearing from the other side. So I don't think it tips the scales at all in favor of Kalshi on the upcoming motion for preliminary injunction, which is set to be heard on Monday, January 26th in Nashville, Tennessee. Maybe I should go to. I've never been to Nashville, but that's going to be the real motion that gets decided. This is nothing more than a placeholder, but it represents an unforced error by the Tennessee Attorney General's office. What's the harm in agreeing not to enforce during the 6-week pendency of a motion for a preliminary injunction? Sometimes, lawyers or state governmental attorneys or federal prosecutors, they want to win at all costs and aren't willing to, yield an inch or give an inch. Sometimes you have to see the big picture here, and the big picture is not to invite the judge to slam a TRO in your face if you're being unreasonable. And I think Tennessee was being unreasonable by not agreeing to at least a temporary hold off on any enforcement proceedings. I mean, what was going to happen in the next 6 weeks that would have just been so catastrophic, particularly since these contracts have been available in Tennessee for close to a year.
Well, I think you're going to enjoy your Nashville trip. It's a beautiful city, and you're going to love it should you choose to go. Before I take you out of state court and back to the
prices have to come down a little bit. Will Prediction News give me a travel budget for this? If the flight fares are pretty high, I could still do it, but it's up in the air at this point. No pun intended. What prompts me to want to go, honestly, is that this is one of those courts that I don't believe do Zoom hearings. Like in San Francisco federal court with Judge Jacqueline Corley, we watched the oral argument on Zoom. Same thing with the Third Circuit oral argument. I don't believe that's the case in Tennessee, and I may need to show up and visit all the country music haunts in Nashville on the way to the oral argument. So that's a game time decision for me.
Yeah, lots to enjoy there. Before I take you back to federal court, I need to tell the people one more time about Prediction Edge. The 2026 elections are the first elections that we're going to have with years of commercial prediction market election contracts, and more than 450 House and Senate seats are going to be up for grabs from incumbents and from the new wave of rising candidates alike. Prediction Edge is a new election platform that brings together real-time prediction market prices, candidate profiles, fundraising histories, polling data, and endorsements. Prediction Edge is the smarter way to follow the election. So check out predictionedge.com. Let me ask you about the AGA state briefs. They filed a few amicus briefs across the country. What do we need to know about the latest round of those?
Two things stood out for me. These amicus briefs by the American Gaming Association, 27 27 states represented by their attorney generals, and the National Coalition of Tribes. They filed amicus briefs in the Ninth Circuit appeal brought by the 3 California Indian tribes against Kalshi, which came a little bit unprecedented because none of those parties or none of those amici participated in the lower court case. Why did they all of a sudden decide that this Ninth Circuit case was so important? Number one, I guess it's a Ninth Circuit case. You have a chance. There are now 4 appeals pending before the Ninth Circuit, all on preliminary injunction, grants or denials. You've got Robinhood, Crypto, Kalshi, and now the 3 Northern California tribes. So you've got 4 appeals pending before the Ninth Circuit that have been filed relatively close in time, relating to many of the same issues. The tribal case raises a separate issue of IGRA. So I think every opportunity in which the states and the AGA, every opportunity that they can weigh in every case, they're going to take full advantage of it. But I think this is more of a situation where the cavalry is coming to the rescue because the California tribes were not ably, I'm not going to say competently, but were not effectively represented in the San Francisco federal court case, because the one issue that they should have won on that they did not win on was the priority of IGRA over the UEJA carve out, right? Jacqueline Corley, the San Francisco federal district judge, found that any internet wagering or any internet trading that occurred within a tribal reservation, that's governed by UEJA, not by IGRA. And that UEJA has a carve out or an exclusion from the definition of bet or wager for contracts traded on DCMs regulated by the CFTC. And that's how she decided the case. And I believe that was incorrectly decided, in part because the California tribes did not adequately address that issue, either in oral argument or in the briefing. And the effort here by the AGA, by the 27 states, and by the National Tribal Amici, I believe, is an effort to try to restore the equilibrium and have IGRA recognized as an important part of the puzzle. Because one of the key arguments that the state governments are making all across the country is that the recognition of these sports event contracts under federal law will have the effect of abrogating or implicitly repealing the Wire Act and IGRA. So the states and the AGA, and obviously the tribes, want to restore the priority of IGRA by highlighting a few legal arguments that the California tribes neglected to raise below or didn't adequately argue below. And the most important of which is language in UEJA that makes crystal clear that UEJA does not alter, suppress, or limit the applicability of the Indian Gaming Regulatory Act. That's crystal clear language plucked right out of the UEJA statute that the California tribes did not utilize in their briefing below. So this is a case of the states and the AGA trying to, properly frame the correct argument so that the Ninth Circuit recognizes that even online wagers, to the extent that they're made on Indian lands, are covered primarily by the Indian Gaming Regulatory Act, and UEJA does not supplant, limit, or subtract from the applicability of IGRA over those bets. And if the Ninth Circuit can recognize the priority of IGRA over UEJA, Judge Corley's decision is going to get reversed on that basis. And without a reversal, the tribes have no point of entry into any of these lawsuits other than as amici curiae. If the Ninth Circuit reverses and recognizes that online sports event contracts traded, listed, or purchased or sold on Indian lands constitute gaming activity, well, if it's gaming activity, because that's where the person is located who makes the trade, places the bet, you need a state tribal compact to be able to offer it, and the tribes have regulatory authority over all gaming activity which occurs on their own lands. And that could that will be a game changer. If the Ninth Circuit reverses Judge Corley on that UEJA versus IGRA issue, it could open the floodgates for more tribal lawsuits across the country, and could put prediction market platforms like Kalshi, Polymarket, and Robinhood on their heels, and not just facing 11 or 12 state governmental lawsuits, but they could be potentially facing multitudes of tribal lawsuits all over the country. So it's imperative that for the tribes to have a direct line of attack against Kalshi et al., They need to secure a Ninth Circuit reversal, which is why these groups found it essential to participate in the California tribal Ninth Circuit appeal when they did not do so in the lower court case.
Mm-hmm. Something interesting happened with two important lobbying groups in the space as well. The American Gaming Association and the Indian Gaming Association. For the non-gaming folks, two groups that do not always see eye to eye. They sent a joint letter to Congress urging them to act on sports contracts. And this is in addition to a letter signed by, a dozen or so senators to the CFTC, also asking questions.
Or Baker's dozen.
Baker's dozen. We'll call it a Baker's dozen. Asking for clarification about how issues like insider trading and sports contracts are handled. What do these two developments tell us about what is being demanded of Congress right now in regards to event contracts more broadly?
Well, and by the way, if the AGA and IGA merge, I guess we'd have to call them AGA-IGA. That would be a new acronym. But what AGA-IGA wants, the American Gaming Association and the Indian Gaming Association, they want Congress to make crystal clear that sports event contracts and casino contracts are beyond the purview of the CFTC and beyond the purview of the Commodity Exchange Act. They're looking for congressional clarification on that issue because we're talking about sports contracts today, but casino contracts are certainly going to be inevitable. Look at some of the recent activity that's occurred in the DCM market. A lot of people may have missed the news about my friend Seth Young's company, High Rollers, which is a publicly traded company which makes casino-style games and virtual slot machines, and all they do are casino-style gaming. They've entered into a partnership, I believe, with crypto or one of the DCMs, and if they're going to be offering event contracts on derivatives markets, they don't do sports wagering; they do casino. The old company ErisX, which had made an attempt to offer sports betting contracts in 2020, the remnants of ErisX have now been taken over by Jeff Ifrah, a well-known iGaming proponent. He's a well-known gaming attorney who's the general counsel and founder of the IDEA Trade Association, which has been promoting and been the number one proponent of iGaming legalization throughout the United States. So now you're beginning to see iGaming people take over companies that are entering into partnerships with DCMs or becoming DCMs themselves, which means if you're reading the tea leaves here, in a competitive marketplace where you're now coming in later than Kalshi, Polymarket, Robinhood, and now you're competing with DraftKings, FanDuel, Predict, Prize Picks, Underdog, and Better. These newcomers are not going to be effective competing for sports event contracts. Their play is going to be casino contracts, and that will happen. I guarantee you that without judicial or congressional intervention, we're going to see the first self-certified casino contract before the end of calendar 2026. So what the IGA, which represents tribal casinos, and what the AGA, which represents commercial casinos, want to clarify, want to have Congress do here is to sort of make clear and pass legislation barring event contracts based on sporting events or casino style games.
So they are really trying to make sure that the casino turf is protected from these federal platform incursions.
But they won't get it. They won't. Listen, as long as President Trump is in office, and as long as he has the support of the Republicans in both houses of Congress, any legislation which does not meet to his liking, any legislation which harms his personal financial interest, doesn't have a chance of passage. You're going to need, 51 or 60 senators to agree on including that kind of language in proposed Dodd-Frank amendments or federal sports betting bill. I think the real upside or the real impact of this statement is that, or this joint letter, is that it acts as a firewall against the possibility that Congress will try to slip in Dodd-Frank amendments to approve sports event contracts or to redline the definition of swaps to include sports event contracts. I think the raising of awareness around this issue by having the two most powerful gaming trade associations weigh in on this issue, I think will be a defensive maneuver to offset or negate the possibility that 60 senators or 51 senators would agree to amend the Dodd-Frank Act to allow the kind of activity that's taking place on DCMs right now. So I think with all the court cases, or at least the recent trend of the last 6 decisions favoring the state governments, I think it's more likely than not that the states will ultimately win the battle in the courts. And if that were to happen, the only lever that can resurrect sports prediction markets would be an act of Congress. So I think that's what the benefit of the joint letter does. Is that it raises the temperature and raises awareness around this issue, and creates a firewall around the possibility that 60 senators would acquiesce to the wishes of the Trump administration. So rather than expect 60 senators to pass legislation barring these contracts, I think the end goal here is to prevent 51 or 60 senators from amending the CEA to allow sports event contracts. Either one is a victory, especially if the courts end up siding in the state's favor.
That CFTC letter that I referred to earlier as well, signed by, it is 12 senators, and they raised concerns about insider trading, market manipulation based on a large trade on Maduro's capture placed on Polymarket on its crypto platform outside of the CFTC jurisdiction. They did not mention sports contracts specifically. Their 9th question is about whether the CFTC has coordinated with state commodities regulators or other appropriate state agencies with oversight of gaming activities. Is this another maybe tea leaf that tells us that there's just not bipartisan support to allow sports contracts on DCMs, and certainly not casino contracts introduced by the iGaming industry?
At least insofar as those 12 senators are concerned, and I believe at least one of them is a Republican lawmaker, John Curtis. I believe he's from Nevada, maybe. So yeah, with only 100 senators and 12 co-signing that letter, it does suggest that you've got at least 12.
Yeah, Curtis is not on this one, so it may be a Democratic letter, but that certainly makes legalization of sports contracts federally a remote possibility.
Yeah, but what do the senators want the CFTC to do? The CFTC is caught in a bind here that while these court cases are pending, they may not want to do anything because with the court cases pending, I think the incoming chair, or now chair, has said they was going to wait for the court cases to play out, because the question of what is and what is not gaming has vexed regulators for generations. And I think what he's saying between the lines is that if he engages in any premature rulemaking around sports event contracts and the court cases end up siding with the states, that those CFTC rules around sports contracts will become null and void. So there's very little that CFTC can do from a formal regulation writing perspective. I think the agency will continue to do what little it has already been doing, which is basically allowing and not standing in the way of these platforms self-certifying all sorts of exotic sports event contracts. We've now come to the point where pitch speeds and tennis serving speeds now have potential economic consequences to the world at large. And those are becoming sports event contracts by virtue of their DCMs, self-certifying event contracts tied to those possibilities. We've now gone off the reservation completely, and we can no longer see the Super Bowl, the Masters golf tournament, or the Kentucky Derby. Had Kalshi confined their event contracts to real games outcomes and to major events, they would have had a much higher likelihood of ultimately succeeding in the long run. The moment they began to, remove any and all constraints and restraints and just went for the whole thing of parlays, props, pitch speeds, I mean, it really did undermine. It undermined their legal case in Nevada for sure, but I think it does overall undermine their legal argument going forward in every other lawsuit. So the CFTC is being asked to put a stop to sports event contracts either by utilizing its existing powers under Rule 40.11, which is a regulatory bar against gaming contracts. So Congress wants the CFTC to actually enforce its own law and or adopt a rule which makes crystal clear that these contracts are beyond the purview of the Commodity Exchange Act, or alternatively impose all these guardrails and consumer protection measures to protect the integrity of sports and to protect consumers. And the CFTC is probably not going to be doing any of those things while these court cases are rolling on, and the legality of these sports event contracts and the question of federal preemption remains unresolved, at least to a 100% certainty. So until we have 100% certainty, there may be very little that the CFTC can do in a formal rulemaking capacity.
We've pretty much hit the big legal developments from the beginning of the year and the first 3 weeks of the new year. What do we need to watch next before we wrap?
Well, I mean, I kept all this stuff in my head, right? When we had 3 lawsuits or 6 lawsuits or even 10 lawsuits, the microchip up here, the M5 chip, could tell you like what was coming next in each cases. I've now reached the point where I'm going to need to create a tracker. Okay, so we've got Polymarket being sued in state court in Nevada. And the Massachusetts case could open the door to more litigation. So what we're going to see next, at least from what we know now, from an oral argument perspective, 3 dates to keep in mind. On Monday, January 26th, which is coming up in a few days, the Tennessee Federal Court will hear oral argument on Kalshi's preliminary injunction motion against the state of Tennessee. On February 11th, the Connecticut Federal District Court will hear oral argument on both Kalshi's motion for preliminary injunction against Connecticut and Coinbase's motion for preliminary injunction against Connecticut. On February 24th, the Illinois Federal Court will hear oral argument on Coinbase's motion for preliminary injunction against the state of Illinois. So you got 3 oral arguments that we know for sure. Important briefs coming up. Today is the deadline for Tennessee to respond to Kalshi's motion for preliminary injunction. And on January 22nd, 2 days from now, that's when Kalshi's reply brief is due. And on Friday, November 23rd, this upcoming Friday, Nevada's Ninth Circuit brief on the merits is due in the Ninth Circuit appeal filed by Kalshi.
There's a lot to look forward to. Give us some support and like this video. Subscribe to our YouTube channel at Prediction News and follow us on X at Prediction News. Dan, thanks as always for breaking this down for us. And I hope you enjoy your hopefully upcoming Nashville trip and any other circuit court trip you're willing to make.
Yeah, I'm going to give my friend Lucinda Williams a call, see if I can, hang out with her, one of my favorite artists in Nashville. Well, we'll see if the prices come down or I just feel like doing it anyway. So we'll hopefully report back on Tennessee in a few days with some inkling of how that hearing went. But thank you again for tuning in to our Prediction News update. And that was a lot to take on here. So thank you very much, everybody.